Okay, so today we're going to look at reforms and alternatives to the jury system. So for this area of the study design, you really need to know two reforms to the jury system. You need to know two alternatives to the jury system, and you must be able to discuss both the reforms and the alternatives. So you must be able to say how the reforms or the alternatives would improve the jury system, and you must be able to say how or why they wouldn't be so good. So discuss is always both sides, so you must have both sides to the reforms or the alternatives. Okay, so in terms of suggested reforms, we're really looking at things that improve the jury system. So something that still retains the aspect of trial by peers, though. So something that looks to improve the jury system, but it still features randomly selected jurors that represent a cross-section of the community. So one suggested reform would be to require juries to give reasons for their decisions. That would mean that the parties to the case would know the reasons for the jury's decision, and they'd be able to see whether due attention had been given to the points of law, whether the points of law had been applied correctly to the case. The downside, and remember you have to be able to discuss these reforms, the downside to requiring juries to give reasons for the decisions would be that it could lead to more appeals as people see what reason they gave. If they felt that that reason was wrong, then people might be more likely to appeal, which would increase delays and increase costs involved. It can also be difficult to come up with one reason from 12 jurors. If there's 12 jurors in a criminal case and they have to come up with one reason, that can be very difficult. In fact, all 12 jurors might have had different reasons for making the decision that they did. And currently that's not an issue, but if we were required them to come up with a decision, that could be, that again would potentially increase the delays in the trial. It also reduces the flexibility of the jury. We saw when we were looking at the strengths and weaknesses of the jury system that being able to apply community values to the legal system is a key strength of the jury. And they're able to do that because they don't have to give reason for their decision, that they can choose to ignore the law if they don't agree with it. If they were required to give a reason for the decision, then it will be harder for the jury to make decisions that necessarily reflect community values. It might reduce the ability of a jury to provide a fair hearing or a fair outcome to a case. A second suggested reform would be to have a specialist foreperson. Currently the jury elects one of the members of the jury to act in the role of a foreperson, to conduct deliberations and act as a spokesperson for the jury. We could employ a specialist foreperson, somebody who's legally trained to act in that role. They then therefore would be able to inform the jury on the relevant law in the case, advise them about that, make sure that they understand the law that's needed for the case. They could inform them about court rules, court procedures, make sure they're familiar with them so that they understand what's going on in court. And essentially they could assist the jury to make sure that they make the correct decision. However, the downside to it would be that their opinion might carry too much weight, that because the jury would see this person who's a specialist, who has legal training, they might be too influenced by them. They might take too much notice of what the foreperson feels is the right decision, rather than listening to the facts of the case themselves and coming to their own decision. So therefore it might reduce again the ability to provide a fair and unbiased hearing. Another suggested reform would be to introduce not proven verdicts for jury, so that if new evidence surfaces after a trial, that the accused can be retried. So currently a jury can just essentially find an offender guilty or not guilty. If they had a not proven verdict, then the accused could be retried later. The downside to that, though, is that the jury may often take the soft option of not proven rather than examining the evidence and reaching a decision based on the facts of the case. That could therefore lead to more retrials, which would potentially increase the cost and delays involved, and also for the accused, if the jury delivered a not proven verdict, then they'd have that sort of hanging over them and could increase the stress involved because they would know that at any day they potentially could face another retrial for the same issue. Another suggested reforms would be to give instructions before the trial to the jury to provide them more technical assistance. If we gave instructions to the jury before the trial, we'd be able to explain the legal procedure involved. We'd be able to explain rules of evidence so that the jury is better able to understand the trial. We'd also be able to give more technical assistance to them if we gave them access to the trial transcript in electronic form, particularly for long trials where there's lots of evidence. Providing it in electronic form would make it easier for the jury to access the transcript of the trial, to search it. We could also give them access to word processing facilities to help them with taking notes about the case and for help in terms of conducting their deliberations. I guess the downside to both of those suggested reforms would they both would increase the costs involved, and that therefore that money needs to come from somewhere. It would increase the burden on the taxpayer or on the parties involved as well, and that could reduce effective access. Another suggested reform would be to reduce the number of challenges and exemptions for jury service. It would help to ensure that the jury is more of a true cross-section of the community, that by reducing the number of people who are ineligible for jury service, therefore it would better reflect the values of the community. However, if we introduce or allow members of the legal profession, either lawyers or judges, onto the jury, they might have too much influence over the other jurors. It could be unfair on carers who have to care for sick or disabled people if they were required to do jury service. In terms of reducing the number of challenges that the parties have over the composition of the jury, again, if we reduce that too much, perhaps that's going to be unfair on the parties. They tend to like to have some say about the composition of the jury. Another suggested reform would be just to reduce the size of the jury. Currently we've got 12 for a criminal case and 6 for a civil case. You could potentially look at reducing that down to 10 or 8 for a criminal case, or down to 4 or 5 for a civil case. That would make it easier for the jury to reach a decision because fewer people have to agree. It would also reduce the costs involved in terms of there'd be fewer jurors that have to be paid. There would be less time spent impaneling the jury. It would be quicker for their deliberations as well, which would reduce the stress involved. It would also reduce costs even further. The downside to reducing the size of the jury would be that it would likely increase the likelihood of an incorrect decision. Also, it would potentially reduce the ability of the jury to represent a cross-section of the community. Okay, so possible alternatives. What we're talking about here is really something different to the current system or the current jury system. And really, the fundamental difference between an alternative and a reform is that an alternative really removes that aspect of a trial by peers. Okay, so one possible alternative would be to have the judge sitting alone. So actually to remove the jury altogether from the legal system, and just the judge would decide the case. That potentially could be better because the judge has a better understanding of the law. They have expertise in that area compared to jurors who are just everyday people. Therefore, they might be more likely to get the decision right than a jury would. They'd have better understanding of the type of cases that they were hearing. It would also reduce the delays caused by a jury. It would also reduce the costs involved because you wouldn't have to pay jury members. Again, you'd save time trial, and then that would reduce the costs of legal representation, court fees, etc. However, a judge sitting alone wouldn't reflect community values like a jury is able to. Also, parties tend to feel more confident in a decision of their peers rather than having a decision imposed by a judge. So another alternative would be to have professional jurors, to actually pay people to actually sit on juries as their job. They would have a better understanding of the law involved and the courtroom procedures, rules of evidence, etc., because they would potentially be the lawyers or people with legal training. They could develop expertise in certain cases, so they'd be able to hear them faster. They'd be more likely to make a correct decision than a jury. However, they could potentially develop biases from hearing similar cases that might reduce the ability to achieve a fair and unbiased hearing. They'd also lose the advantage of being independent that a jury has, and they're no longer that buffer between the state and the parties. Final alternative we look at is specialist jurors. These would be people who are impaneled especially for particular cases. So they'd be better able to understand the evidence in the case. We'd be looking at people like medical experts if it was a medical case, potentially impaneling a jury of accountants if it was a financial case or a corporate dispute. So therefore, they'd be able to better understand the evidence, they'd be better able to decide the case fairly. However, if you're impaneling specialists in this area, they may have biases either for or against members of their profession, and practically it would be difficult to be able to get together either 6 or 12 doctors just to sit on a jury. It would also be very expensive because you'd have to pay these people to do the jury service. Just to recap, again, you need to know possible reforms and alternatives to the jury system. You must know 2 reforms, you must know 2 alternatives, and you must be able to discuss each of them. You must be able to say why the reforms or alternatives would improve the jury system and also why they wouldn't be so good. And that's it.